Welcome back to the deep dive. Today, we're tackling a really critical area of professional responsibility. We're talking about stepping out of the clinic and into the courtroom.
Hmm.
Now, this might sound like a topic just for senior consultants, but actually, for anyone facing high-stakes situational judgment tests like the MSRA, SJT, well, this is fundamental stuff. It's about your ethical backbone.
It absolutely is. And today, we're going to be distilling the core guidance from the GMC's document, acting as a witness, and, merging it with the principles from good medical practice.
Right.
So our goal isn't to give you legals training. It's to give you a really high-yield framework that helps you spot the safest, most GMC-compliant action in those pretty tricky exam scenarios.
Okay, let's jump right into that pressure cooker situation. Here's the kind of dilemma the SJT just loves to create. You're asked to write a factual report after a serious clinical incident at your hospital. The solicitor for the trust, your employer, hints that maybe the report should, well, minimize any blame, use language that kind of obscures accountability. How do you even begin to navigate that?
That's the core conflict, isn't it?
Hasn't it?
And it's exactly why this guidance exists. Look, if you take away just one single thing from this deep dive, let it be this.
Okay.
In all circumstances, the duty a doctor has to the court and to justice overrides any obligation to the person who is instructing you or paying you.
Any obligation.
That duty demands total independence, honesty, and impartiality. End of story.
That sounds great in principle, but, practically, my NHS trust pays my salary, their solicitors telling me what they need. How do I actually uphold that duty without, torching my professional relationships?
Well, that's why they test it. It tests the boundary between loyalty and truth. The guidance links directly to the most serious GMC duties. We're talking honesty, following the law, competence. The examiners know this is hard to follow when you feel your career is on the line.
I see.
If a doctor gets this wrong, if they lie or obscure facts or give an opinion they aren't qualified to give, that's a serious failure of professional standards. It's the kind of thing that genuinely puts your GMC registration at risk. The SJT is checking if you prioritize the law or your employer.
So we're not just talking about being a bit embarrassed. This is the ultimate professional risk. Okay, so to tackle this, we really need to understand the two different types of witnesses the GMC talks about because the rules are quite different.
Exactly. We have to clearly separate the witness of fact from the expert witness. Now, for most junior doctors, you'll start out as a witness of fact.
And what does that mean?
It means you provide evidence based only on things you were personally involved in. So, clinical findings, observations, actions. Your testimony has to come straight from the clinical records made at the time.
And you have to be really clear about fact versus opinion.
Crucially, yes. The GMC is so explicit about this. You have to clearly distinguish between what is factual evidence, what you saw, what you did, and what is your professional opinion based on that evidence. You cannot drift into speculation.
Got it. So the expert witness then, they are the ones who are expected to offer opinions, but I'm guessing there are strict rules around that too.
Correct. The expert's role is to help the court on specialist matters that are within their competence. They have to review all the relevant evidence, not just their own notes. Their job is to give objective, unbiased opinions to help the judge.
Even if that opinion hurts the case of the person who hired them.
Especially then. And if there's a range of professional opinions on something, the expert has to acknowledge that range and explain why they've landed on their particular view.
So the safest doctor is the one who really understands these limits and is ready to justify every single decision. That brings us nicely to a high-yield framework, a sort of step-by-step guide.
Yes, this is what will get you the marks in the exam, because it's the safest path.
Okay, let's hear it.
Step 1. Understand the role and your limits. As soon as you're asked, you clarify. Am I a witness of fact or an expert witness? And you must make sure the task is within your competence. If someone asks for an expert opinion and the instructions are vague or outside your expertise, you have to refuse, or at least ask for clarification.
Step 2.
Ensure integrity of records. You review all the source material. Your evidence has to be based on records that are full, accurate, and impartial. You have to actively check that the information is correct, and you must never, ever deliberately leave out relevant information.
Even if it harms your side's case.
Yes, especially then.
Step 3.
Communicate clearly and simply. The court is not a medical setting. You have to use language that a non-medical person can understand. That means explaining all your abbreviations, all the jargon. The GMC even encourages using diagrams.
And the last step, this feels like a big one.
It is. Step 4. Manage conflicts and changes without delay. This is a huge SJT testing point. If a conflict of interest comes up, maybe you realize you've treated the person before, you declare it immediately to everyone.
And what about if your opinion changes?
Same rule. If you get new evidence and your professional opinion changes, you must inform your instructing solicitor right away. And if they drag their feet and don't tell the court, you have a direct duty to tell the court yourself.
Wow. That is a direct duty. Okay, that structure is really clear. But to make it stick under exam pressure, we probably need a memory tool.
I agree. We can use a mnemonic that sums up the core duties for the evidence itself. Just remember the word COURT.
COURT. Okay, I like it. So C is for
Competence. Know your limits. You have to be upfront about the boundaries of your knowledge and expertise. Don't get pressured into commenting on something you were only vaguely involved in.
right. Oh, must be for objective.
Exactly. Your evidence has to be unbiased, independent, impartial. Your personal feelings about a patient's lifestyle or their behavior, they cannot be allowed to color the professional evidence you give.
Yeah. Understandable.
You've got it. Use plain English. If the judge and jury can't understand you, your evidence is useless. So you explain every single technical term.
R has to be for records.
It does. Your entire testimony must be based on those full, accurate, fair clinical notes that were made at the time. If it's not in the record, you can't rely on it.
Which leaves T. And that has to be truth.
It's the overriding duty. It demands honesty. It's more important than any fee, any loyalty, any instruction from a solicitor. You are there to serve justice, first and foremost.
I think a good visual for that is imagining the scales of justice sitting directly on top of your patient's notes.
That's a great visual. It's impartiality balanced on a foundation of fact.
Perfect. So let's get really practical now and talk about how the exam designers actually test this. What are the common setups we need to look out for?
Okay, pattern 1. You're asked to give an opinion that's outside your current grade or expertise. A classic. A solicitor for a consultant asks you, an F1, to comment on a complex management decision.
What's being tested there?
Your awareness of your own competence limits. The best action is to politely but firmly refuse. Or you answer, but you make it crystal clear that the matter is outside your competence. You do not speculate to try and look good.
Okay, pattern 2.
You discover new information that completely changes your written expert report. This tests your duty to update. You have a legal duty to make sure everyone knows about this change immediately.
So what if the solicitor says, don't worry, I'll handle it later?
That's a trap. You push back. If they don't notify the court, you're obliged to do it yourself. Hiding it is seen as actively misleading the court.
Pattern 3.
You receive confidential patient information for the case, but there's no clear confirmation of consent for disclosure. This tests information governance.
So you don't just assume it's okay because it's a legal case.
Never. The best action is to stop work, return the information, and get written confirmation that the patient is giving consent or that there's a court order.
And the last one, pattern 4.
Having a strong, maybe negative personal view of the patient. For example, they've been repeatedly abusive to staff. This tests your impartiality. It's tough, but the exam demands that your personal views on their character do not affect the objective clinical evidence you give.
Now, let's flip this around. What about the trap answers? The options that sound plausible but will lose you marks.
Yes, let's talk pitfalls. Trap 1, delaying disclosure, waiting until the court hearing to mention a conflict of interest or a change in your opinion. That's a huge no. You have to declare these things without delay.
Trap 2.
Hiding your limits.
Nah.
Not being upfront when your opinion is qualified or when you don't have enough information to be certain. You have to be transparent about uncertainty. It's a strength, not a weakness.
I can see how people would fall for that one.
Yeah.
Trap 3.
Prioritizing who's paying you. So, giving testimony that's biased toward your hospital or the solicitor who hired you. Your duty is to the court, full stop. You're helping the judge find the truth, not helping one side win.
And the final trap.
Using jargon. Submitting a report that's just a wall of medical terminology without any explanation. Your evidence has to be understandable to non-medics. Always explain abbreviations.
Okay, this is a lot to take in. Let's try and nail this with some really quick rapid-fire points. Maximum impact for exam day.
Let's do it. If you need to use abbreviations in your report,
Do explain them clearly or provide a glossary.
if you're asked to give an opinion on someone without examining them,
Do explain the limits this places on your opinion.
if a potential conflict of interest arises, even a small one,
Do disclose it immediately to everyone involved.
if you see another expert witness behaving unprofessionally,
Do not let it affect your own evidence. You maintain your own standards. Perfect. That brings us to our summary. What are the 3 definitive takeaways for this critical SJT topic?
First, your number one duty is to the court. That means independence and honesty above everything else. It overrides any payment or instruction you get.
Second, always work strictly within your competence and be really clear about the difference between factual observation, the witness of fact role, and unbiased professional opinion, the expert witness role.
And third, keep full, accurate records and report any changes or conflicts of interest without delay, even if that means escalating to the court yourself if your solicitor doesn't act.
So what does this all really mean for your prep? Well, mastering this topic shows the examiners you get it. You understand professional accountability under serious pressure, which is just central to MSRA success. And if you're looking for more structured practice on topics just like this, head over to passsomesra.com for some really targeted SJT revision.
And to finish, a final thought to leave you with.
Go on.
If you treat every set of notes you write and every clinical conversation you have as if it will one day be scrutinized in a courtroom, you've already become the safest doctor.